how did you go from being a systems development consultant into this area that you then went into? What led you into that and propelled you into really doing what is now journeyman work in legal research?
Well, at the time, I was doing programming and database development, mostly like systems level stuff for a major investment bank in San Francisco. And my neighbors at that time knew that I had a background in political science because I told them that I had graduated from UCLA and then went on to do graduate work in public administration. So at one point, there was a journalist in our small town who was beginning to report the problems with the 16th Amendment, and people were coming to me, naturally asking me what my opinion was, and I was trying to blow it off, like, well, if there's a problem, Congress will just fix it, excuse me, I have to go to work. That was more or less my attitude, just sort of like, don't bother me with this. But at one point, a veteran challenged me. He said, this is a constitutional matter. This isn't just something they can fix with a regulation. And I said, oh, yeah, that's right. It takes 2/3 of the states to amend the Constitution. And he said, no, it's 3/4, Paul. So I was a bit, mad at myself for having made that error. But, I had been away from legal studies. I took constitutional law at UCLA from a fabulous professor, Richard Longacre. But, I had drifted away from that and had developed a profession in, systems development, computer, intensive stuff. I was fluent in Fortran. So anyway, I had to make up for my error, so I started to dive in, and the further I got into this problem, the more interested it became for me because I just had an intellectual curiosity now, and I had to do something about the error I had made. And one thing led to another, and I was asked to help a tax defendant in a criminal case. And as a consequence of that, people started sending me a bunch of materials through the mail. We didn't have the internet back then. This is about 1991. And I'm reading everything I can get my hands on. And unfortunately, my client at the time got convicted of a misdemeanor failure to file, but we did defeat the felony tax evasion charge. And I was just heartbroken because they sent him off to federal prison for a couple years.
Wow.
And he said to me, I don't have a time right now or the wherewithal to get to the bottom of this. Do you? And I said, well, I will do my best for you. I mean, that was like a father to his son, passing the baton.
Yeah.
So he went off to federal prison, and I had to follow through with that promise to him. And I went off, I remember right in the middle of the trial, I took a break and I went off to this conference in Denver, and I ran into a man named John Knox. He has since passed away of lung cancer, but this man had such a unique take on this whole problem. My whole focus at the time was 16th Amendment, hasn't been ratified, da-da-da-da-da. And I noticed that all of the other conference organizers there in Denver were giving him a cold shoulder. They didn't want to hear what he had to say. And I remember I came down the elevator one day, and here was John Knox arguing with another conference attendee, and I just stood there and listened. And the man who was talking to John got up and left out of frustration. He said to John, "This is never going to go anywhere. I'm leaving." So I sat down, and I looked at John, I introduced myself. I said, "John, I hope you don't mind. I was just listening to that, but I came in right in the middle. Would you mind starting over?" And he said, "Are you going to argue with me?" I said, no, I've just never heard any of this before. Can you start over? He goes, "Are you sure you're not going to argue with me?" And I said, "Yeah, I'll give you my word. I'm not going to argue with you, but I would like to stop you and ask questions as we go along, because you're onto something I've never heard, and I'm not reading it in any of this voluminous material that's coming to me." So he started over. It was just the two of us. He started getting into the various definitions of United States, and I had not been exposed to that at all. And before long, there were like 30 people standing around us, and I'm asking him questions, and he's clarifying. And I looked around, and I realized, wow, this conversation that we're having must be something, very interesting to all these people, because they're standing here in rapt attention. So we ended up that conversation by his agreeing to send me a brief he was working on. So I sent him $20, and he sent me the brief. It ended up being a winning brief. And I thought to myself, there must have been, a supernatural reason why I ran into him the way I did and had an opportunity to, settle him down and make him realize that I was not an adversary. I was just very, very intellectually curious about, what he was saying. So I took his brief, and then I started pursuing a completely different approach to this problem, namely by sort of putting the 16th Amendment aside for a moment and focusing on the code itself, that if there was a fraud, it would reveal itself somewhere in the code. And he had already done that for me, but his command of the English language wasn't, really high level. He had to struggle at times to express himself. But I basically was able to pick up this thread that United States has multiple meanings, and there are two classes of citizens, not one. And I had never, ever heard that before. And I thought that was really strange when he said that to me the first time. Like, what are you talking about? I thought we were all, Americans. We were all members of one class of citizens of the United States. So I don't know, initially, the first time I heard it, I didn't know what he was talking about. But then he gradually laid it all out. And in his brief, of course, he cites court cases that I looked up. Now, we didn't have the Internet in 1990, so, I launched into a very long, drawn-out research project that required me to drive an hour in one direction over to the county law library, and pour through really old, dusty law books. And I was still trying to prove to myself that there was either only one class of citizens in America or there were two. And I just used the training that I had acquired at UCLA and then later UC Irvine to say to myself, if I'm going to prove this, I've got to use really rigorous rules of evidence. I just can't be throwing out my opinion. Because if it's two classes, then I've been misled for a long time, and all of my neighbors have been, my family, my teachers, scoutmasters. We've all been misled, and I need to get to the bottom of this. So I went about testing that theory. Is it one class or is it two? And, of course, to prove that there are two classes, what I needed to find were court cases that said two, T-W-O, instead of one. And they were extremely hard to find. At first, I was striking out. I wasn't finding any cases that said in so many words, there are two classes of citizens in America. Well, eventually I ran across the work of Richard McDonald, and he got me looking into the 14th Amendment. And that's where it really opened up. He had one of those bulletin board systems where you dial in.
Yeah.
Remember that before the Internet?
That was my earliest experience with interacting with computers. Absolutely.
Yeah. So I downloaded all his stuff and started digging in. Sure enough, the can of worms, if you will, started to open itself up, and I realized, oh wow, I have to go all the way back to the Civil War to pick up the thread. And sure enough, once I dove into that material, and it was a significant body of material. I mean, it wasn't the kind of thing you could read in a couple of hours. I mean, I probably spent another 50 hours really going through those cases and the various documents that I was downloading from his website. And I finally began to locate a few key cases that were brave enough, these are judges now, who were brave enough to say, we have two classes of citizens in America, not one. And some of those cases actually turned out to be the U.S. Supreme Court. So now I knew I was onto something. But boy, they were hard to find before the Internet. And now, of course, if you know where to go at my website, you can find those cases in 10 seconds because we went through the trouble of assembling them all the important ones, and putting them in chronological order. So now there's just no question in my mind that there are two classes of citizens in America, and there have been ever since 1866. And prior to that, there was only one class of citizens, and that was the break point, if you will. That's when a second class of federal citizens was introduced into the law, but Congress chose language to confuse it with the primary class of state citizens, which had already, been recognized in the Constitution as of June 21st, 1788. So there are two basic concepts that I want to share with your listeners tonight, without dragging them through all of these, legal details and all these cases. And, it's a daunting project to dive in at the level I did. But I want to leave your listeners with just two very fundamental concepts tonight that will help them in ways that they probably don't even realize and won't really appreciate for some time. There are two words or two terms in federal law that take you very, very far. One is the word citizen, and it comes in two flavors. One has a capital or uppercase C, and the other is a small or lowercase c. So that's one half of this equation, if you will. Mm-hmm. The other side of the equation is the word United States. And I want to begin exploring the term United States first, because once we nail down the meanings of United States, then how these two classes of citizens relate to those various permutations will make a whole lot more sense. If we start with the word citizen and then end up with a discussion of United States, I think your listeners might be a little bit more confused by that approach. So what I did earlier today was to draw a triangle and draw it like a mountain so that you have a point at the top and the line or the side opposite is horizontal. So it looks like a mountain.
Right.
Okay. And now annotate the point at the top with the word nation. You might also use the word country, but let's just keep it simple. The point at the top is the nation, and this is kind of like the peak on an umbrella, okay? Now, the point at the lower right, we want to annotate with the phrase 50 states, or 50 states of the Union.
Right.
Those are the stars on the flag. And the other point, lower left, is federal government. Okay, so we have a triangle. It looks like a mountain. The pinnacle or the top of the mountain is annotated nation. The point at the lower right is annotated 50 states. And the point at the lower left is federal government. Now, in federal law, the term United States has at least three meanings, probably more. But it took until 1945 before the U.S. Supreme Court finally admitted that the term United States has multiple meanings. That in and of itself is rather significant because the term United States figures prominently throughout the Constitution as of the day it was ratified in June of 1788. So why it took them so long to make this official is anybody's guess, but I think they were very negligent in waiting that long. Anyway, I'm going to read to you exactly what the Supreme Court said in 1945. The term United States may be used in any one of several senses. It may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. Okay, so that's our point at the top of the triangle, right? Then it may designate the territory over which the sovereignty of the United States extends. Let's come back to that one because that's a real problematic permutation there. And then lastly, it may be the collective name of the states which are united by and under the Constitution. Okay, so that's our 50 stars on the flag, that third one. Now, come back to this second one. The term United States may designate the territory over which the sovereignty of the United States extends. Did you notice that United States is used twice? And in fact, it's a tautology because the term United States is defined by using the term United States in the definition. Now, that in and of itself is a grammatical violation because you're not really defining it. You're using the word in the definition of the word you're defining, so that's a grammatical violation. But also, the territory over which the sovereignty of the federal government extends is a concept that we've explored in great detail in the federal zone, and it's not the whole nation. The federal government does not have unlimited jurisdiction inside the 50 states. This is a fundamental observation that anybody will make when they read the Constitution because it limits what the federal government can do when the Congress enacts laws that apply inside the states of the Union. It's very limited. It's a grant of enumerated and limited powers. And there are tons of court cases that have said that very same thing. I want to point out something else, though. United States has a fourth meaning, and it's the name that you will find in lots of federal laws that describe the federal government. For example, when the federal government sues somebody, the party is called United States. Yes. And it's a singular noun. It's not a plural noun. And people stumble on this a lot because states is plural, right? But the term United States in this context, when it refers to the federal government, it means
a singular entity, right?
A singular entity, yes. It is often referred to in that fashion, IT. Congress will say its jurisdiction, or it can do this, or it was sued. So it can sue, and it can be sued, and Congress has said the United States can be a plaintiff, and the United States can be a defendant. So really, there are at least four meanings, and John Knox said there are many, many more, particularly when Congress goes wild and they want to issue a special definition. For example, there are places where they'll say state includes only the District of Columbia, and therefore United States is limited to the District of Columbia. So anyway, Congress is not supposed to do that. They've been told by the Supreme Court you can't redefine these terms that are in the Constitution, but Congress has been doing that anyway for a long time, and I don't know if they're ever going to stop. But it's very abusive when they do that because they're not supposed to redefine terms that are found in the Constitution. Unfortunately, the term United States has different meanings in the Constitution. So we got off to a bad start when the Organic Constitution was ratified originally on June 21st, 1788. It already had this problem. It already had occurrences of the United States that refer to the 50 states, or actually there were far fewer back then. There were only 9 that were required to, make it supreme law. And then you find later on, like in the Guarantee Clause, clearly United States there means federal government because the United States must guarantee to the states of the Union a Republican form of government. So the two terms are clearly juxtaposed there. We have United States and states, right?
Yeah. Let me just stop there for a minute. Where did this term federal come from? How does it relate to a Republican form of government? Because now we throw into the mix all of these other things, and the word federal is one of them. I mean, clearly it goes back early in our history. We had the Federalists and the Anti-Federalists and the battles that went on there. But was there in itself an organic meaning to the word federal as it relates to this distinct entity?
Right. Well, we have a federal government as opposed to a national government. It's a federal government because it started off as a federation of states. The states got together and said, well, there are things that we can't do for ourselves, like national defense, so we're going to charter an agent who can do these things for us. And that was done in the Articles of Confederation. But it was never a single government with an overarching authority, everywhere it had jurisdiction. It wasn't a national government from the beginning. It was never conceived to be a national government the way it is in, say, France, where you have just, one monetary lawmaking body that applies to, all the people within that particular country.
Yes.
It was always a federation of initially colonies, and then they decided to become their own governments. And those governments got together and said, well, we need an agent for foreign affairs. We need to tax all of us for purposes of self-defense and so on and so forth. So they wrote the Articles of Confederation, but that charter got into some serious problems right away. And the problems that were identified in the Articles of Confederation would take us too far afield tonight, but it's already been, those problems have been very, very well documented, in history books if you know where to look. So when the people who tried to organize the Articles of Confederation admitted to themselves that it wasn't working, they reconvened at Philadelphia and they started over. They basically threw out the Articles of Confederation and wrote the Organic Constitution as we know it today. and put it out to the states, and that created a federation through ratification of the Constitution. It created a federation of sovereign states, if you will, who retained all the rights of individual sovereign states except for the authorities that they delegated to this region.
Right. And that is probably the best distinction we can make in terms of defining that. Thank you, because that right there nutshelled it beautifully.
Yes. So we were never, the federal government, our government in Washington, D.C. was never a national government, and it's still not one today, despite their efforts to morph us out of, a republic into a democracy. And that effort is, malicious, and it's ongoing, it's well-financed, and they may actually succeed in pulling it off. But at the moment, the law in America is that agent called the federal government, also called the United States, must guarantee a Republican form of government to all members of the Union. That's written in the law. That's the guarantee clause, and that is a guarantee that can be enforced. It should be enforced, and I've tried to enforce it, but, if you look at the history of my efforts, there have been some pretty major obstacles put in my way whenever I've attempted to do that, but nevertheless, the law is still there. Okay, so I don't want to get into this triangle in too much more detail. I mean, I don't want to get into some of the theories about the occult and the Masonic influences on the
right. We do that all the time here, so that's okay.
Yeah, no, I just want to give you this triangle as a way of distinguishing the three definitions of the United States that are recognized by a standing decision of the U.S. Supreme Court. So you're always standing on very good authority when you rely on a standing decision of the U.S. Supreme Court. Okay? Now, let's move on to the question of citizenship. The problem with citizenship from the beginning was that it used the word citizen of the United States in three key places. And it did that right from day one. To be a representative in the House of Representatives, you needed to be a citizen of the United States, capital C. To be a senator, you also had to be a citizen of the United States, capital C. And to be president, you had to be a natural-born citizen of the United States, capital C. So they added that qualifier, natural born, and we don't want to spend too much time talking about that because that's a whole quarter's worth of analysis and cases. But anyway, when you look at these three offices, they are the only offices in the federal government that are elected. All the others are appointed. So we vote for senators and we vote for representatives and we vote kind of indirectly for the president. But anyway, those three qualifications all have this one thing in common. They all require that the candidate be a citizen of the United States. So, a very fundamental question that keeps coming up and shows up in all of these cases that I was able to assemble. The question that keeps coming up is, what does it mean? Okay? What's the legal meaning of the phrase citizen of the United States? Well, if you haven't read the history and if you haven't been exposed to any of this in school, right away you're going to say, well, I don't know, because United States has three meanings. It could mean three different things at least, couldn't it? Now that we know United States has three meanings at least, probably more, the term citizen of the United States is vague. It doesn't really pin down exactly what's intended by that phrase. So I had to go looking for court cases that answered that question. And we found a beautiful case that involved a judge who'd been a California state judge under the California Constitution, the first version of that Constitution, the 1849 version. He said, oh, let me explain this to you. It's not that hard. The word United States in these qualifications clauses, it means States United. There you are. That's a judge who signed the California Constitution of 1849. So he was in a position to know what he was talking about. And that settled the matter in such a nice, clear fashion for me basically, the framers had neglected to realize that they were using United States, in different ways with different meanings in different contexts. So in this particular context, it's important to realize it had only one meaning, and it is citizen of one of the states united. That was true of the qualifications clauses starting June 21st, 1788, going all the way up to the present. But there was a big bump in the road right after the Civil War ended. Now, do we have time to get into the post-Civil War problems and legislation
Absolutely.
At all tonight?
Yep.
Okay.
Yep.
Maybe this is a good segue to talk about what happened just before the Civil War. Actually, the problem that arose before the Civil War came up when a very brave black slave by the name of Dred Scott sued for his freedom. I don't want to go into all the various arguments he was making, but basically his owner took him to some states where slavery was outlawed. So he said, hey, when I'm in Minnesota, I'm not a slave anymore. So he sued for his freedom, but you know what? He lost. That case went all the way to the Supreme Court, and a landmark decision came out of the U.S. Supreme Court. It was a 7-2 decision. The opinion...
Okay. Paul dropped off. I'm not sure what happened. Bear with us here for a minute, folks.
I don't believe in racism. I think it's an affront to God's design.
Okay. We lost Paul's phone line. Let me call him back. Okay, we got Paul Mitchell back on the line. Phone line dropped. Gosh, what a surprise. That almost never happens. So back at, do you remember kind of where we left off, Paul?
Yeah, well, we were talking about the decision of the U.S. Supreme Court in Dred Scott versus Sanford, and I was saying that the Chief Justice made two very fundamental points that I wanted to share with your listening audience. I don't think there's any question that he was correct when he said that apartheid was the law of the land and that black slaves were not citizens. And that was also written into the Organic Constitution. They were considered 3/5 of people. So there was no question that the Constitution was a racist document when it was first ratified. But then he made another holding. His second point is probably the most controversial. A lot of people were looking to the Supreme Court to solve this problem and outlaw slavery, but he said, we don't have that authority. We are the U.S. Supreme Court, and we don't have the authority to amend the Constitution. And he pointed to Article 5, and he said, if you find this result offensive, the Constitution has a mechanism for amending itself. Go ahead and utilize it. But we, the U.S. Supreme Court, have not been granted authority to amend the Constitution directly. We don't have that power, so I can't do that for you. And unfortunately, an enormous debate was inspired by this decision, and the two sides, one side for slavery and the other opposed to slavery, they just got entrenched. And I think a lot of them who, chose to one side or the other failed to read the whole opinion. If they had, the answer was right in there. Amend the Constitution, but don't look to us to do that.
Now, this was a very long opinion, wasn't it?
Oh, yeah, it's over 450 pages. I've read it twice, and it takes some time. And it's tough going in places because there's a lot of, very unusual concepts in there, like municipal law and what this state did and what that state did, and they got into all kinds of various issues like voting and family law. They just covered the gamut. But there's no question that they left no stone unturned, and the Supreme Court came to the conclusion that apartheid was the law of the land, but if the nation wanted to change that, they had to utilize Article 5. They couldn't turn to the Supreme Court for a solution. Now, Abraham Lincoln was one of those people who decided to attack the Supreme Court rather than follow their advice. And I don't think that was his finest hour. I personally feel he made a very tactical mistake. Do
you think that Lincoln was demagoguing, or was he seriously just, the man was trained as a lawyer, but in the day, well, even as now, politicians tend to build on demagoguery. Do you think, and this is just an opinion, do you think that was the case, or do you honestly think that he was not fully cognizant of what that decision said?
Well, I think emotions were running high, and you know how emotions can cloud your better judgment? I think that happened to a lot of people, not just Abraham Lincoln. In his defense, though, I think the Lincoln-Douglas debates made his particular preference crystal clear, and it cost him that election, okay? And when he was finally elected president, the South started seceding right away. It was because of his election to the, office of presidency that the South figured, well, this guy's going to change the law, he's going to outlaw slavery, and that was one of the reasons why they started seceding right away. It wasn't like years. It was just a matter of weeks after his inauguration that the South started bailing from the Union. So he's a very complex man, and I think he deserves, a lot of the praise that's been showered on him as a result of the way he handled the war and kept the Union together and so on, but he also made a lot of mistakes. I'm not an expert on Lincoln, so maybe that would be a topic for another call-in discussion. Maybe you'd be better off finding a Lincoln expert. But having looked at the history of the law, I think he made a very serious mistake by attacking the Supreme Court's decision and not following their advice immediately. I mean, he was a lawyer at that time, and he should have known what to do. He should have coined or drafted a proposal to eliminate apartheid from the law and to at least consider a naturalization law, propose a naturalization law or an amendment to the naturalization laws, because Congress knew how to do that. The first naturalization law was enacted in 1790, so Congress knew how to do that. So there were really two sides to this coin then. When the Dred Scott decision was issued, basically blacks were told, one, you're not citizens, you're property because you're slaves, and we need a constitutional amendment to give you citizenship. So it's like two sides of the same coin. One side of the coin says you're a slave, and because you're a slave, you can't be a citizen. The other side of that coin is you need a constitutional amendment for freed black slaves to be citizens of anything. So that's where I came in, and I said to myself, well, I can draft this correct amendment. Now, this leads us to another question that I want your listening audience to focus on, because it took a civil war to basically decide on the battlefield whether or not states could secede, and the South, as you know, lost. They surrendered at Appomattox. And then a couple weeks later, I think it was General Johnson, he also surrendered. So the Civil War came to an end, thank God, after 600,000 casualties, most of which died from disease. I mean, what a horrible thing. I almost wept the other day just thinking about all the pain and suffering that war caused. And I have to wonder if the war might not have started if Abraham Lincoln had straightened this problem out, in 1857 or so. That's just speculation. But what we do know is that right after the Civil War ended, Congress proposed the 13th Amendment, which is probably one of the most significant historical events in American history. I don't think there are very many other events that equal the significance of the 13th Amendment, because the southern states that had, been fighting to keep slavery, not only did they stay in the Union, but they voted to outlaw slavery, and their votes were necessary to reach that three-quarters threshold. Now, a lot of historians, I think, are remiss in failing to appreciate the overall significance of the ratification of the 13th Amendment. And I place a lot of emphasis on it because, there were these radical Republicans in the Congress who wanted to punish the South, and they did everything they could to punish the South even after the war was over and even after the President issued the amnesty proclamation, which was a very generous thing for him to do. Very few Southern officers were prosecuted. for, their participation in the rebellion. It could have been a lot worse. I mean, the federal government could have taken, enormous revenge on all those people, but that didn't happen. I mean, one of the most generous things that Abraham Lincoln did was to pen a very, very generous amnesty proclamation. And if you read this one case that I urge your listeners to study in detail, it's the Utah Supreme Court in 1968, Dyett versus Turner, D-Y-E-T-T versus Turner. They say, basically, the South was counted upon to ratify the 13th Amendment, and that outlawed slavery and involuntary servitude. So, half of the coin was settled. Slavery and involuntary servitude were now illegal as a matter of constitutional law.
Mm-hmm. For the listeners out there, too, by the way, these links are posted on the offplanetradio.net site. There's a post there, Paul Andrew Mitchell Notes and Resources. That link is on that page. So,
yeah, great. Okay, now at this point, what happened became very, very problematic. I think the issue of, the citizenship of these free black slaves probably could have been settled much more easily if Congress had just exercised its authority to establish a uniform rule of naturalization, and that's one of the authorities that Congress has had in the Constitution since the beginning.
Absolutely, yeah.
Yeah, and I think they could have done that, and if they had made their intent crystal clear, we are simply offering these freed blacks an opportunity to apply for a naturalization certificate, or Congress could have made it even easier. All you have to do is register to vote. You can do that now because you're free. And if you declare that you're a citizen of Missouri or you're a citizen of Texas or whatever, we'll accept that. I think it would have settled the issue so much more efficiently than what ultimately happened. What ultimately happened instead of that was that the radical Republicans got together, and without really making their intent crystal clear, they enacted a statute called the 1866 Civil Rights Act, and that ended up having the effect of creating a second class of federal citizens. But instead of calling them federal citizens, which they should have, to make it crystal clear that it was different from the original, state citizen class in the qualifications clauses, instead of doing that, they just changed the C in citizen from an uppercase C to a lowercase c. Now that was fraud, because they were trying to create the false impression that these freed blacks could now become state citizens. But the Supreme Court had said, you can't do that without an amendment. See, here Congress is trying to do it sort of through the back door by circumventing the Supreme Court's holding just 10 years earlier. They're trying to do it with a statute, but they didn't say we're doing this by way of, say, a group naturalization. They didn't express their intent, and a lot of people had to sort of infer the intent because of all the politicking that was going on at that time. Emotions were still running really high. The war had only ended months earlier. So the question of what the intent of Congress was when they enacted that law actually became clear in the ensuing political brouhaha. The leader of the radical Republicans was this guy named Thaddeus Stevens, and he basically said, look, we have to elevate this 1866 Civil Rights Act to the level of a constitutional amendment now. He finally realized, we've got to do it through the amendment process, so let's take this language and elevate it to a constitutional amendment. But they threw in all this other stuff. They added another privileges and immunities clause. They added another due process clause. They threw in equal protection. And if you read all the way down to Section 4, they threw in this big zinger that had nothing to do with citizenship. They said the validity of the public debt shall not be questioned. I don't know what on earth that had to do with citizenship, but that came out eventually much later. Now,
that's still biting us in the ass today, by the way, because that's one of the keys upon which they hang a whole lot of other things, including the IRS, as I understand it.
Oh, yeah, exactly. Yeah, they're trying to say it's in the Constitution. So all hell broke loose at this point, because to vote on that proposal to amend the Constitution, you need to read Diet versus Turner and a couple of other law review articles I've confirmed recently and loaded into our internet website. People don't know this, but the Congress voted to unseat all the U.S. representatives from the southern states and all the senators. So those southern senators and southern U.S. representatives were unable to vote on this proposal to amend the Constitution with the 14th Amendment. I mean, it just turned into a political brawl, and what the Congress did was like totally outside its authority, totally unlawful. And they were basically attempting, in my opinion, to punish the South using these political maneuvers.
Was this the period that we refer to as the Reconstruction?
Yeah, exactly.
Okay, so they were using... See, Reconstruction was never properly taught in history even back when I went to school. It was reframed differently. I don't think a lot of people understood, and it took me years to understand, that this was basically an occupation of the South with military force to basically coerce them into coming online with what they wanted to do, the agenda.
Right, so the proposal to amend the Constitution with the 14th Amendment was sent out to the states, ostensibly to conform with Article 5, and the southern states immediately looked, they saw right through this and they said, there's no way, if you're not going to let our senators and representatives vote on this, then we're voting no on this proposal to amend the Constitution. Well, the northern states, you have to remember, they had trains and maybe telegraphs were just coming on. I don't know the exact sequence of the technology, but, they didn't have anything like our communication system today. And the northern states looked at it and thought, well, this seems reasonable. The Supreme Court said they needed a constitutional amendment, so we're going to vote for it. Well, word of the subterfuge finally reached the northern states, and they started to reevaluate their decision to ratify the Constitution. And then the Reconstruction Acts hit because Congress was furious at the southern states for voting no. Now, remember, they had voted yes to abolish slavery. So they were counted upon to, exercise their authority to reach the 3/4 required for the 13th Amendment. So they had every right and authority. The southern and northern states had every right to vote any way they wanted on this 14th Amendment proposal. But when the South voted no, the Congress of the United States retaliated in a very, very vicious way. They wrote a law requiring the president to send the troops back into the South and to occupy those southern legislatures and throw out all the white legislators and suit up the black men they could find on the street and tell them, we are not removing our troops until you ratify this 14th Amendment and make major changes to your Constitution. Well, that was extortion.
Yeah, absolutely.
When news of that reached the northern states, they went, hold everything. We are not going along with this. Many of them changed their votes from yes to no. They just, voted again and said, now that we know what this is all about, we are changing our yes votes to no. We refuse to approve this proposal to amend the Constitution with the 14th Amendment. So now you had a group of southern states that initially voted no. They were forced, at the point of a bayonet to change their votes to yes. So that was extortion. The northern states had voted yes initially and changed their votes to no when they saw the whole story, when they learned the whole story. So now the Secretary of State, William Seward, he's got a problem, right? When Nebraska joined the Union right about that time, he issued an edict that said, well, now you need 28 to ratify this 14th Amendment. You need 28 states to reach 3/4. And you know what he did? He only counted yes votes. He said, well, if you voted yes initially, if you were a northern state and you voted yes initially and you changed your vote to no, I'm going to count that as a yes. And then if you're a southern state and you voted no initially and you changed your vote to yes under duress of military occupation, I'm going to count that as a yes. When he did that, he still only got 27. After he had said to the world, we need 28 states to ratify the 14th Amendment. So they came up one short, even counting in that weird cockamamie fashion. And this is all recited. These facts are all recited in enormous clarity and in enormous detail in that Utah Supreme Court decision that I encourage everybody to read. I mean, this is fraud. And you know, the Supreme Court had earlier ruled, I think it was in the 18th century, that we do not make law by force or by fraud. But you know what? That 14th Amendment is still in the Constitution. Every copy of the Constitution that you will find in every federal depository library will show this crazy amendment. Now, I'd like to talk a little bit about the content of the amendment with a focus on Section 1.
Now,
you see,
can you kind of orient here on the timeline between the 13th Amendment and the 14th Amendment? Where are we in time? Because we've got a war in between these two, right?
Right. Basically, the history was 1856 was Dred Scott. The Civil War started in 1861 and ended in 1865.
Okay.
The 1866 Civil Rights Act came next. Then the proposal to amend the Constitution with the 14th Amendment. And then the votes of the southern states, you know, saying no. And then you had the Reconstruction Acts. And finally, when all the dust settled, Seward declares the 14th Amendment law fraudulently in 1868.
Okay. There was a point there, something that I was fuzzy on, and it doesn't matter. I was just trying to, you know, have a continuity flow going in my own mind, because the 14th Amendment has been vastly criticized for a long time on substance, and I still don't completely understand what the 13th Amendment enacted versus the 14th Amendment, and I think you explained that real well there. So,
oh, thanks. Well, let's look at the language of the 14th Amendment just for a minute here, and I think you'll see how it attempted to elevate to, you know, constitutional status the language that was in the original 1866 Civil Rights Act. So, when you couch the proposal to amend the Constitution, and when you couch the 1866 Civil Rights Act in the context of all this brouhaha and all these machinations and all this force and fraud and martial law, the real intent of the radical Republicans becomes painfully obvious. It wasn't just a naturalization law. They were trying to force this second inferior class initially on the freed blacks, but then they tried to say any person who's born or naturalized in the United States is a citizen of the United States and of the state in which they reside. So that was the language that they adapted from the 1866 Civil Rights Act. Let me read it verbatim now. Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Well, if you don't know that the United States has three meanings, you might be easily duped by this key section of the 14th Amendment. And let me tell you something. If you know where to look, that one sentence there has generated more litigation than any other clause in the Constitution. And the Constitution has generated a lot of litigation, believe you me. But the 14th Amendment is such bad law, it has generated thousands and thousands of court cases, and so you have all these judges that are trying to interpret it, and they don't agree. The courts that have issued all these various opinions on all these various nuances, you can't reconcile all of them because they do not agree with each other. And you know why? One of the reasons why is because the United States had three meanings, but they didn't say in this language which of the three they were using. And then they say, subject to the jurisdiction thereof. Well, what does thereof mean? Does that refer to the 50 states, or to the federal government, or to the whole nation? And then they say, all these persons who are either born or naturalized in this United States are citizens of the United States, small c. So there you see they've elevated the 1866 Civil Rights Act up now to, they attempted to elevate it to constitutional status. And then they say they are also citizens of the state wherein they reside. So that very language itself reveals their recognition of two separate classes, one of the federal government and one of the state.
But in one sense, in that language there, and you may not agree with this, my understanding of it is, Paul, that what they did was they effectively didn't free the people who were called slaves, but they brought what had originally been understood as the free men in the United States, natural-born citizens, into this 14th Amendment redefinition. They effectively annexed the original free citizens into this 14th Amendment.
That's what they tried to do, but you know, the courts ruled otherwise. And that's out of all these court cases that I ended up finding, they disagreed with that intent. Okay. They basically said the status of, white state citizens was not affected even in the slightest by the ratification of this amendment, assuming it had been ratified. They said there was no attempt or intent to modify the, organic state citizen status for the white people who were always state citizens between 1788 and, the Civil War, and still are even today. So the courts that have ruled on this particular, construction, don't agree with that. But you're raising an historically significant fact, however, and that is that as of right now, Americans look at this and they say, well, I was born in the United States. Or if they were naturalized, they'll say, yeah, I was naturalized in the United States. So according to this amendment, I must be a citizen of the United States, small c. So when they register to vote, they say, yeah, I'm a small c citizen of the United States.
Bingo.
And when they file tax returns, they say, yeah, I'm signing it under penalty of perjury, because that's for U.S. individuals. U.S. individuals are citizens of the United States and resident aliens. That phrase does not embrace state citizens at all. So you have all of this effort on the part of the federal government through subterfuge and extortion and, taxation and everything else, trying to morph the whole country into a population of federal citizens, forgetting this original organic class of state citizens, almost through efforts of genocide, but they won't admit that. The feds won't admit that, but they try to act like that organic class of state citizens doesn't exist anymore. But when you get to the end of Diet versus Turner, you realize this amendment was never ratified. It's not law. It's just put in there to look like the feds have a national jurisdiction over all people who are born anywhere inside the 50 states. That's the interpretation the federal government has been forcing down our throats, and it's just not true. It's just not correct. It's not supported by the facts. It's not supported by the law, and it's not supported by the court cases that have ruled on the real meaning of this, proposal, particularly when they leverage the 1866 Civil Rights Act with all of this extortion and military invasion. If they had just left it as a naturalization law and be done with it, I think American history would have been completely different. So now, what we've got to deal with presently is that there are still state citizens. That class is still available. It's still recognized in the law. The qualifications clauses have never been amended. And then we have all these people that have been duped into declaring or signing under penalty of perjury that they are federal citizens in effect. And what did it for me almost more than anything was my finding in a law dictionary that federal citizenship has a legal meaning. When I saw that, I said to myself, man, that definition is very condemning of the Congress. Imagine if Congress had used the term federal citizen in all of these laws that they've passed that apply only to small c citizens of the United States. You and I would look at it and we would say, well, I'm not a federal citizen, so that law doesn't apply to me. But you see how they colluded the two classes simply by changing the capitalization to a small c? That was fraud. And it was fraud in the 1866 Civil Rights Act, too, because they should have used the term federal citizen in that law. because that was the law that created this second class. There's no question about that now. That's the origin of this second class, this second inferior class of federal citizens. Prior to that, there was only one class of state citizens, and I can show you the court cases that have held that. Panel versus Roanoke is a really pivotal one because it said this second class wasn't even contemplated when the organic constitution was being drafted. That's a federal court being honest for a change. Mm-hmm. This second class wasn't even contemplated, okay? So you had that period between 1788 and 1866 when there was only one class of state citizens. And I mean one and only one. Not two, not zero, not three, one class. And they are the class of people who are still today eligible to make law in the House of Representatives, make law in the U.S. Senate, and, sign laws in the office of the President. Now for the bad news. Because all these states have gone along with this fraud, what you find is that to vote or serve on any jury, regardless of whether it's a state or federal jury, whether it's a civil or criminal jury or even a grand jury, you have to declare that you are a citizen of the United States, small c. So we've got a really screwed up, twisted situation happening all across the country right now. Well, the people who are qualified to serve in the House of Representatives and in the Senate and in the White House cannot serve on juries, and they can't vote. And the people who can vote and serve on juries are not eligible to serve in the House of Representatives, in the Senate, or the White House. Tell me that isn't messed up.
Well, it's a complete inversion. Here's the happy side of this, and I learned this a few years ago after I finally understood all this. It was actually a way to decline jury duty by simply refusing to state that you are a U.S. citizen.
Yeah, I've had clients come to me with that question.
Yeah.
I've been served with a subpoena here. I want to obey the law. I'm not trying to get out of jury service on the basis of some stupid reason, but the law says I must declare that I'm a federal citizen, in effect, and I'm not. So what should I do, Paul? And I tell them, well, you write to the jury commissioner and you show them these cases, and you just tell them, I'm not in that class. I'm in this other original class, the state citizen class that was recognized in the Constitution from the beginning. And usually the jury commissioners look at this like a hot potato. They don't want to touch it.
They just pull from the jury pool to find somebody else that's either ignorant or compliant.
Yeah, because you don't want to commit perjury. You don't want to say, well, I'm a federal citizen because I want to perform my jury duty. You don't want to do that either. I mean, that could get you in trouble. That might be a felony.
So the 14th Amendment was really the beginning of the formation of what you defined in your work, the federal zone.
Yeah.
As a mechanism. It
turns out that the United States, in the phrase citizen of the United States, when C is a small c, it doesn't mean states united the way it does in the qualifications clauses. What it means is the federal government. It's that other leg of the triangle. So small c, citizen of the United States, basically means citizen of the federal government. And in this context, the federal government and its limited areas like D.C., the areas where it's the state legislature, if you will, they're on a par with the state legislatures, and the laws that Congress enacts for places like D.C. and Guam and Puerto Rico, they're called municipal laws. And this category of law is very different from the laws Congress can enact for the whole nation, like raising taxes and, organizing military and patents, copyrights, naturalization, okay? When Congress enacts laws for places like Puerto Rico, it's doing what, say, your state legislature does when it enacts laws for your state. And when the Washington state legislature enacts laws for my state, those laws are called municipal laws. Now, when you combine all of these little areas where the federal government has exclusive legislative jurisdiction and there's no state like Puerto Rico, when you combine them all together and you combine it with the District of Columbia and all these other federal enclaves like military bases, you get an area where Congress is the state government in effect, because there's no state governor, there are no state courts, and there's no state legislature. Congress is the city hall for those areas. When I wrote my book, it just seemed obvious that that was an area we ought to call the federal zone, because the states are the state zone. And that was the title of my book that we published first in 1992. And it came up in the context of federal income taxes, because lo and behold, Subtitle A of the Internal Revenue Code is imposed only on federal citizens and resident aliens. And we knew that because we looked at the regulations, and they attempted to create a liability for only those two classes of Americans, not for state citizens. So right away we knew there was a very important distinction right in the regulations between state citizens on the one hand and federal citizens on the other. But it got even more interesting because all of Subtitle A basically falls into this category of federal municipal law. It only applies to D.C., Guam, Virgin Islands, American Samoa, and Puerto Rico. And it redefines a state in a very subversive kind of way, but none of the 50 states are even mentioned in that particular definition. And it was only after I published the book when I got some really dramatic confirmation of this. I mean, at first I would never have believed it, but, you know, there was this letter. I don't know if you've seen it. Have you read The Federal Zone, by the way?
I have, yes. Yeah, I
Okay.
was part of my basic research 6 years ago when I was in battle with the IRS.
Yeah. Well, do you remember the letter from Representative Keneally?
Yes.
In Connecticut? Remember one of her, it wasn't her, somebody in her district, it was somebody from California who wrote to her and said, can you please tell me what the meaning of state is in this bill that you've authored, and how does it compare to the meaning of state in the Internal Revenue Code? And she didn't know the answer. This was interesting. Mm-hmm. So she sent the question off to the Congressional Research Service, and there was another group, Legislative Council, I think, was the other group, and these legal experts came back to her and said, well, in your anti-terrorist bill, the one you're writing, state embraces all 50 states. It's intended to include all 50 states, but in the Internal Revenue Code, the term state embraces only the District of Columbia, Guam, Virgin Islands, American Samoa, and Puerto Rico. And she simply took what they told her, wrote it up in a summary letter, and mailed it back to this guy in San Diego. And it couldn't be clearer. It says state includes only. You know, there's no ifs, ands, or buts there. These legal experts made it very clear that in the Internal Revenue Code, the word state at Section 3121E, that's Social Security, by the way, it embraces only these areas that we call the federal zone, and none of the 50 states were even mentioned. So very clearly that the legal experts were telling a congresswoman what to tell this person who had written to her. And I read that and I said, man, oh man, am I glad I have this, because I came to that very same conclusion all on my own before I even saw this letter from Representative Keneally. So I threw it into a subsequent edition, you know, up there in the preface, and reproduced it verbatim so that people could see that, you know, I wasn't making this up, that this is something Congress has been doing for a long time. They've been redefining state to limit it to areas that don't have anything to do with the 50 states of the Union. It's everything but the 50 states of the Union. You know, like Puerto Rico, which is a territory, and it's not a state of the Union. Congress is the local legislature. So we came to the conclusion it was a conclusion that we had to come to because we went down the right road. We got to the end of that road and we said the Internal Revenue Code is federal municipal law. And that conclusion has withstood all kinds of assaults from all kinds of various quarters. And the courts that we've presented this to just basically freak out. They don't want to admit that I'm right. And they usually find some way to get around this. But we followed up with a lot of litigation, and we introduced the book into a lot of different court cases. But let me tell you, the federal judges that we've been up against, they don't even want to talk about Diet versus Turner. They get really angry. It's like, you know, we're exposing their whole scam, and they don't have the intellectual wherewithal, nor do they have the intestinal fortitude to admit they've been wrong about this for all this time. but state citizens are not even mentioned in the subtitle A of the Internal Revenue Code.
Wow.
You find it in some really out of the way places, like they're mentioned just very briefly in the removal laws, like if a case starts in a state court and for some reason it needs to get moved over to a federal court, there are laws that govern that process.
But that's a change of venue. That's not the transmigration of the identity of the individual person or the entity you would call a state, right?
Correct. Yeah. The feds are trying to morph the entire country from a constitutional republic to a legislative democracy, and they're taking on the ideology of the Roman Senate way back, when Caesar was the dictator of the Roman Empire. If the Roman Senate enacted a law for Rome, the Roman army would enforce those laws out in Palestine and North Africa.
Right.
Anywhere in the Roman Empire, they would enforce those laws. And that's why the late Howard Freeman described it as Roman civil law. That's what the Congress is trying to do. They're trying to say, we can legislate anything we want, and it applies to all you Americans, even if you're out in the 50 states. And the way they get around that is they say, well, if you're a federal citizen because you filed a tax return or you voted, you are subject to federal municipal law no matter where you are on planet Earth. We have that reach. Our municipal law will reach you, provided that you've declared somehow, we've got a record of you saying you're a federal citizen. That makes you our subject. So we're going to treat you like a monarchy, and you are our subject. And that word subject is right in the 14th Amendment. If you go back and reread that, subject to the jurisdiction thereof, what that means is subject to the municipal jurisdiction of the Congress. That's what that really means. And it took us a long time to figure that out, but let me tell you, that explains a lot of the original intent of the 1866 Civil Rights Act. You're basically subjecting yourself to federal municipal law no matter where you are, on planet Earth. Even if you were on the space shuttle or International Space Station, the feds are going to say, you're one of us, and you've got to pay us these taxes. Now, state citizens are not subject to federal municipal law any more than they are to the laws enacted by adjacent states. I mean, here I am in Seattle. I'm not subject to any laws of Oregon or Nevada or California. Those are foreign laws as far as I'm concerned. And the same thing is true of these federal municipal laws. They're foreign with respect to the states of the Union. One really easy way to understand this is a hard one for a lot of people, but if you look at the definitions of foreign and domestic corporation, this will lay it out just in very, very simple terms. Because the 10th Amendment preserves to states certain rights, states have the power and authority to create and domicile, corporations, and those corporation laws vary from state to state. So if a corporation is established, let's say in California, it's a domestic corporation only within the confines of California. And with respect to all the other 49 states, that corporation becomes a foreign corporation. You see the distinction there?
Yes.
This is how municipal law works. And if a corporation domiciled in California is trying to do business, say, inside Utah, it needs to register with the Secretary of State and say, well, we're a foreign corporation with respect to Utah, so we're just checking in with you and we're registering because we want to do business in your state because your state is foreign with respect to our home state. So it's all a relative kind of concept, but this business about foreign and domestic corporations really highlights the distinction between laws that your own state would enact for people who live and work inside your home state versus, say, the laws of an adjacent state that are all foreign with respect to your home state. Well, the same thing is true of the District of Columbia. When Congress enacts local laws, they're just like a state legislature, and those laws only apply in that area. As a matter of fact, a really good example is the Uniform Commercial Code. That's federal municipal law, and it says right on page 1, this law was enacted for the District of Columbia. But
I see people in the Patriot movement using UCC all over the place.
Yeah.
And here's the thing about it. UCC varies from state to state as well, does it not?
Well, it's supposed to be the same,
Having said
and when the feds make a change, I think the states have agreed to sort of follow along so that it's all the same text. For example, 1-207 moved to 1-308, and some of the states were a little slow in, changing their codes. If you're going to use the UCC, use the citation that's recommended by your state legislature. Invoke the state law that applies to the state where you live and work.
Because UCC is still implemented through the state secretary, the office of the what is the state
Secretary of State.
Secretary of State, yes. So
well, they tried to make it uniform, but they get out of sync occasionally, and that's not a big problem. I just have to caution people: don't invoke the federal UCC, because you're basically telling a federal judge that you're subject to the District of Columbia version. You don't want to do that. So I show people how to get around that. That's just a little detail, but the UCC is a good example of federal municipal law because it says right on page 1, this law is enacted for the District of Columbia. I wish Congress would do that more often. They don't do it often enough. They very often, use the word state in a very limited sense, but they don't clearly define it. So they want people out in the states to assume that, that law applies to us out here too because it applies to the states. It gets worse. Actually, if you know where to look, there's evidence that there are two kinds of states, and the Supreme Court has actually recognized a state within a state. And we found some regulations that made this real obvious. And when we started talking about it on the Internet, President Clinton, Bill Clinton, ordered these regulations removed from federal depository libraries because they were all parallel. It's like one regulation that applied to capital S states, and then there was an identical regulation that applied to small s states. Yeah, it was just, parallel, A and B, all the way across. And I put that into some litigation because, the IRS sued me a couple times. I put that into some litigation, so it was actually in a court record.
Why did the IRS sue you?
Well, they were retaliating at me for having authored the book.
Okay.
And when I worked for that investment bank, I made some money. I made some serious money, so they wanted me to pay taxes on it.
Sure, yeah.
And I refused. I said, no, I don't owe you any money. So, Judge Von Walker got this pleading the first time, and he tried to pontificate during that hearing, and he was lording it over me. But it went nowhere. I got this very quiet dismissal about 6 months later. There was no appeal or any contrary motions or anything. When he read my pleading, I don't think he realized these regulations were actually in the Code of Federal Regulations that made it so obvious that there was this parallel government being created. So I was surprised because I was ready for bear. I wanted to fight all the way to the Supreme Court. They were just trying to summon me. I ended up going to the summons, but I just took the fifth, and then they left me alone after that. But I got this order from Judge Von Walker. He's the chief judge of the U.S. District Court in San Francisco.
I've heard of this guy, actually, yeah.
Yeah, he just dismissed the case. I don't even think he was moved. I didn't move him to dismiss it. He's not supposed to do that, but he just said, this case is dismissed with prejudice. So I figured I must have hit a nerve somewhere in that brief. By the way, that brief is in the Supreme Law Library if you want to see it. Just write to my email address, supremelawfirm@gmail.com, and I'll show you where to find that winning brief.
Yeah, I should point out for anybody that doesn't know, if you're doing any kind of legal research in areas we're talking about, this should be your first stop. It is voluminous, it is annotated, well documented, and I got to say, like I said earlier, I consider this to be a landmark website for this type of work.
Oh, thank you very much. I appreciate the plug. Well, it's nice to have winning briefs because people are always coming to me saying, well, we don't have any wins. I heard you don't have any wins. I go, wait, I don't know where you heard that, but I won twice in my own case. Do you want to see the brief? People see the brief and then go, holy cow, I can see why John Von Walker wouldn't touch this with a 10-foot pole. But after that, it actually went downhill from that point because by the time I moved over to Arizona. Do you know the story of the grand jury case?
I know some of it. I know a little bit about it, but not all of it, no.
Well, I figured by that time we had exposed the Internal Revenue Code. I mean, I was very, very comfortable with my knowledge, having been, published in the book. And, one summer the book just sold like hotcakes. It was really fun shipping all those books. But when I was invited to Arizona, just a few weeks after I arrived there, my client there got served with a grand jury subpoena. And I said to myself, yeah, maybe this isn't a grand jury after all. If they have to be federal citizens, maybe there's some court cases that say this type of class discrimination may actually invalidate the entire panel. Well, sure enough, I did my due diligence at the time, and we found cases that were decided on the basis of laws that would not allow blacks on juries, in southern states. And the Supreme Court said, no, these are not lawful juries because this type of class discrimination invalidates the entire panel. So I put that up before the late Judge John Roll. Remember the judge that was assassinated?
Yes.
Yeah, he was presiding on this case, and I said, we should put a stay on this whole proceeding because the Jury Selection Act is manifesting class discrimination against state citizens. Man, he changed his whole demeanor towards me when he saw that pleading. Before that, he was like totally in control of the courtroom and so on. And when I started putting arguments like that in front of him, he just changed his whole demeanor. Of course, we nailed him for obstructing the mail we were sending to the grand jury, so he actually became very, very defensive, and he actually admitted it in open court one day. So the whole tenor of that case changed from, straightforward litigation and proper challenge.
He basically openly admitted that he was obstructing justice?
Oh, yeah.
Wow.
I said to him, your assistant here signed the green card of registered mail that I dispatched and posted to the grand jury. How did you get this mail? He said, well, I have all of it, but I didn't open it. Oh, I had to charge him with 28 counts of obstructing correspondence. And then he openly admitted in court, too, that he handed it to the U.S. attorney. Instead of delivering it to the grand jury, he handed all our pleadings to the U.S. attorney. So that admitted conspiracy, and then it was jury tampering. So I ended up having to charge him with over 100 felonies. I'm sorry that he ended the way he did, but he did not handle that case very well. I'm sorry to say, but he did not rule on the motion challenging the Jury Selection Act. I think that was just too hot to handle. I found out very early that this knowledge about two classes of citizens, this is like a tightly held secret among federal employees and federal officers. They don't want state citizens knowing that this status is still available to them and has never really changed. They don't want Americans knowing this. But
they do know it, don't they? They do know it.
Yeah. They do know it, yeah. And when you put the arguments in front of them, you can just see they freak out. Like, well, I don't want to be the one to have to rule on this, you get that kind of response. It's like, well, you're a federal judge. What difference is it? You got a lifetime appointment. You're making all this money. So you rule against the Jury Selection Act. It's not going to redound back to you. But somewhere, I've always felt like maybe somebody's threatening them. I can tell you this, when I filed that motion, the U.S. attorney on that case got flown back to Washington, D.C., pronto. I think somebody wanted to talk to him, like, you're not dealing with just your average litigant here. This is how we're going to deal with this. Yeah, and then, of course, we went up before the Eighth Circuit in the Gilbertson case, and we really formalized it there. That opening brief really formalized it. Topic A said jury selection is unconstitutional in this country. So the grand jury that indicted him and the trial jury that convicted him, they were not lawful juries. We got some one-pager out of the Eighth Circuit, and it ended up naming 3 imposters, judges that never had credentials. So the whole legal system is really up in the air right now in America. And we get targeted because we make constitutional arguments, and that's so outside any kind of authority claim that, they might assert against us. I mean, we're entitled to have questions of law dealt with objectively, without bias. by qualified judicial officers, and that's just not happening.
Well,
so I've taken it upon myself to tell people I probably have more authority on these questions than Eric Holder, because his credentials are invalid too. I just tell people I'm acting on behalf of the United States, and this is what the United States is telling you. And so far, the marshals are tolerating it here in town. They've had 4 meetings with me, but they don't challenge me on these points. They realize that when I make a stand on some point of law, that I've already researched it, and I've got the court cases and the regulations and the acts of Congress to back me up. So they leave me alone here in Seattle.
You used an important word there, the imposters. You've stated, for instance, that in California, the bar is completely in contempt in terms of not being licensed, and that the judges, from federal judges down to probably the local district judges themselves, probably are deficient in oath. Talk a little bit about that and what you discovered about the deficiencies that occur with the judges and court officers.
Well, you probably know that my book was stolen and modified and then hosted on the internet by about 129 players, 20 of whom were major colleges and universities. One of them was my alma mater, University of California. So I sued 129 named defendants beginning 2001, just before 9/11, as a matter of fact. I remember because I went back to the court to get subpoenas issued, and they said, we changed our security requirement because of 9/11. You're going to have to show a driver's license or something. And I didn't have one, so we had to work something out so I could get in the courthouse. So it was right around that same time that I had filed that lawsuit. And I challenged all the attorneys who showed up for certain defendants to produce licenses, because the California law is pretty clear, and not one of them would do it. And I got subpoenas served on these same attorneys as well, and they were in contempt of those subpoenas. They never did produce the license that's required by the California Business and Professions Code. So as we went up the ladder, I got up to, the magistrate had been a member of the state bar, and he should have known he had a conflict of interest, because I put that paperwork right into the record. I said, look, these people don't have licenses. I'm entitled to a default judgment. There's a court case from the Ninth Circuit that says, if a corporation doesn't show up in court under auspices of a licensed attorney, it's default judgment time. Well, he had a conflict of interest, and so did the federal judge. I should say federal robe, William Shub. Then we go up to the Ninth Circuit, and the same thing started happening up there. About a fourth of those had been members of the State Bar of California, and they refused to produce licenses too. And then we got to the U.S. Supreme Court. Whoa, 3 of those had been members of the California State Bar. And to make matters worse, by that time the Department of Justice was helping me, and they realized I wasn't a terrorist. I'm a blue-blooded American. And they were helping me produce credentials for these various federal judges all the way up the ladder. If they had them, they would write to me and say, here's the Presidential Commission for so-and-so and such. And they would also say, well, we don't have one for this, that, and the other federal robe. By the time we got to the Supreme Court, 3 of those turned up without presidential commissions, which means they cannot sit on the U.S. Supreme Court at all. You have to have a presidential commission to be a federal judge or justice. So effectively,
decisions handed down by these courts would technically be null and void because they're not operating under commission. Is that correct?
Not just technically. It's just flat, black and white. They have no authority to preside on any cases, issue any rulings. All their acts are void. And I showed the marshals various cases that have said that, and they can't get paid either. Yeah, the marshals are looking at this going, holy shit, we got a big problem here. Yeah, and they finally said to me, we wonder if our credentials are valid or not. And I said, well, I wasn't going to bring that up. I'll leave it up to you guys to decide that. They did advise me to go back to the Office of Management and Budget and Office of Personnel Management and get the very latest situation. But both of those federal departments said to me, we have not followed the Paperwork Reduction Act, so we don't have any authority to remove the OMB control number from all these defective credentials. Yeah, they're using a form on the Internet. It doesn't have an OMB number. And if you don't have an appointment affidavit, you're not a judge. If you don't have a presidential commission, you're not a judge. Yeah, it goes way, way back. So by the time I made this discovery, I went back to California and started investigating all federal district judges throughout the state of California and all members of the State Bar of California. And all federal district judges in California had been at one time members of the State Bar of California. It was 100% correspondence. The overlap was perfect. So I refiled my lawsuit in the Superior Court of California, and I ended up charging all 200,000 members of the State Bar of California with multiple state and federal felonies because they've been committing mail fraud, obstruction of justice, misrepresentation, conspiracy. It's a long rap sheet, but I had to because federal law requires that you report a federal felony when you've encountered proof of it. And here I am litigating now a civil RICO action against all these same defendants. And, of course, the same imposters stepped in and obstructed that case as well. But by this time I had more ammunition, namely a subpoena had been served on the State Bar of California. The State Bar refused to produce any licenses for any of the 200,000 past or present members, many of whom had been federal judges. Now get this, 9 years later, an attorney in California finally showed me the front side only, but he refused to show me the back side where his signature should have endorsed a certificate of the oath. That's what I was really interested in, was that signature that's required by California state law. Well, I went back to that attorney and I said, you didn't send me the backside. I don't know if this is valid or not. It says you're a member in good standing, but you didn't show me your signature. He never answered that. So after all that time, I ended up with 1/2 of one license to practice law for all 200,000 members. So the whole legal system in California is going down the toilet.
But you would have to assume that is statistically representative of most of the other states as well.
Well, I asked myself that question when I moved over to Seattle. I said, I wonder if it's as bad here. So I went to the Supreme Court straight away, and I asked them that question through, Washington state law now. And you know what? In a matter of weeks, I had licenses for all of them.
Wow.
There was no problem. They just produced it right away. No argument, no challenge. I think I had to pay some nominal fee, for the clerical photocopying. Mm-hmm. But they were, completely cooperative. So it wasn't a question of the problem being true everywhere. I think it's more of a problem that's unique to California.
Because of the
bar.
And is there not also a lot of illegal activity that's being conducted through the courts in California?
Oh, boy. Yeah. Is there ever?
I don't want to pry the lid off of that, but let's just say that I've understood it to be that I think the district courts in California are basically fronts for drug running. I'll say that. You don't have to if you don't want to.
Well, we have a document in the Supreme Law Library that was certified by an LAPD detective, Gary Ween. He has since passed away. But he nailed 2 federal judges for being kingpins in the cocaine trafficking ring that's being run out of the U.S. District Court in downtown Los Angeles. Mm-hmm. That was Dean Pragerson and his father, Harry, who's on the Ninth Circuit. Dean turned up without any credentials. And, my motion that was filed in a case in Santa Ana was handed over to him. And he issued one of the most ridiculous rulings I've ever seen come out of a federal court. He says, I don't understand these remedies. Well, we wanted to abolish the IRS. I wanted to litigate it. He said, I don't understand these remedies. But that guy turned up without any credentials at all, and he's running a whole narcotics racket right out of the U.S. District Court in downtown Los Angeles. Yeah. That's how bad it is.
Yeah. Is there any possible way to gain remedy in situations where, who judges the judges? Who enforces the law on those who enforce the law? When you no longer have people who are accountable, is there a process that you go through that you are pursuing that will bring these people into line? You filed all of these lawsuits. You have subpoenas out there that are in dishonor, and yet nobody seems to move on this.
Yeah, we're up against it in that sense. I mean, you understand this pretty well. Let me just deal with Eric Holder for a second.
Okay, yeah, let's go there.
Yeah, that's a good one because he's like the top law enforcement officer in the country, or claiming to be. Well, when Obamacare, hit the courts, Washington joined that group of states that was suing Obamacare.
Yes.
And I jumped in and I noticed all the parties that I was interested in knowing if Eric Holder had credentials, and Sebelius was in there, a couple of other cabinet members, Department of Labor, Secretary of Labor, and so on. And then also Geithner, I wanted his appointment affidavit. And all of those appointment affidavits are being pulled off the internet copy, and none of those have valid OMB control numbers.
Okay.
So all of these people turned up without valid credentials, including Eric Holder. So I've had to tell him, I'm sorry, Eric, but you're not Attorney General. This is the law of the land. If you don't have a valid appointment affidavit that's been duly witnessed by somebody who has authority to administer that form, I mean, it can't be a county dog catcher. Nothing against county dog catchers, right? But they're just not authorized to administer this form. Well, a lot of the people who administer those forms don't have credentials. So the form is rendered invalid by virtue of the fact that it doesn't comply with, Section 2903 in Title V. And I got into this with the marshals. They wanted to know how deeply I went into this, and I answered every one of their questions immediately. I said, this violates this law, and that violates that law, and this all goes back to the U.S. Constitution, where it says they will all have oaths of office. So we don't have an Attorney General at the moment, and I'm thinking in a couple of key cases that I'm investigating at the moment, I may actually commandeer that office for purposes of the paperwork. Okay. Now, I'm not going to, show up and try to oust Eric from his office. He's got a lot of people working.
The actual recording of tonight's radio broadcast was over 2 hours and 49 minutes, so we're going to break it here somewhere near the midpoint for the sake of people out there who are downloading the files and maybe want to burn them to CD or some other media. We're going to return in part 2 to continue American Apartheid with my guest, Paul Andrew Mitchell, on Off Planet Radio.
This is Off Planet Radio.
So we'll continue here with the conversation.
So we don't have an Attorney General at the moment, and I'm thinking in a couple of key cases that I'm investigating at the moment, I may actually commandeer that office for purposes of the paperwork. Okay. Now, I'm not going to, show up and try to oust Eric from his office. He's got a lot of people working for him there, right?
Okay. So this goes right to the heart of something I wanted to ask you, and I know you've explained it before, but for the sake of this audience, you're acting in the capacity as private attorney general. I don't think many people understand that. The first time I'll be honest with you, the first time I saw that, I went, what is that? That's bullshit. And then I began to dig through your site, and I'm like, okay, this is pretty legitimate. Whoever this guy is, he's serious. So how is it, by what virtue do you have the title of private attorney general, Paul?
Well, number one, the racketeering laws have a civil remedy at Section 1964. And the purpose of that was explained in the legislative intent. Congress basically said, we don't have public prosecutors who are trained and experienced in busting rackets. So we're opening up an opportunity. Yeah, they just basically said U.S. attorneys and county prosecutors and state, attorneys general, they don't have experience busting rackets, so they don't bother. They leave the rackets alone. But racketeering had become a really serious problem nationwide, and Congress decided to do something about it, so they enlisted private citizens. They said, we want your help in enforcing this law, and this is what you can do for us. If you step into this role properly, we'll award you triple damages off the top. It's automatic if you prevail. And so they threw in something that didn't even show up in the U.S. Code. They said, we are allowing these statutes to be liberally construed to effect their legislative intent. So the private citizen has two things going for him or her, assuming they're willing and able to step into that role and follow the procedures that are laid out. They can exercise the authority of an attorney general in limited situations, and they have this extra benefit of being able to apply a liberal construction rule to these statutes as opposed to a strict construction rule. And furthermore, Congress said it only takes 2 RICO predicate acts to constitute a pattern of racketeering. So if somebody commits mail fraud twice, that's racketeering. The definition of racketeering is liberal in and of itself. It only takes 2 during any given 10-year period. So the way a private citizen does this is that he goes in, he or she, I don't mean to be gender specific here, I'm just going to say he, okay?
Sure. Yeah.
He goes into court representing the United States or the state of California or the people of the United States of America, ex rel. Now that's a Latin abbreviation that means ex relatione, out of the person's or the citizen's relationship to this entity. He can move the court. He can file a criminal complaint. He can commence a civil RICO action, you see, and doing it properly in the paperwork designates that person as a private attorney general. And now when the Supreme Court was asked to rule on the constitutionality and, enforcement of this law, they said, here's the intent, we agree with it, and the intent was always to allow private citizens to become private attorneys general, not only to investigate rackets diligently, to do a good job investigating, but also to prosecute them. Now, the word prosecute has a very important legal meaning. The Supreme Court has said you can prosecute a racket as a private attorney general if you know what you're doing. Of course, you have to follow rules of evidence and rules of procedure. You just can't walk into a court and, start, throwing bowling balls in everyone's direction. You got to follow procedure, motions and, service of process and so on and so forth. But if you do it right, and I've done it numerous times, okay, you become a private attorney general. And you have the concurrence of the Congress of the United States and the U.S. Supreme Court. Now, the executive branch in the federal government doesn't like this, but it's because of their negligence that Congress enacted this law in the first place. It's because of people like Eric Holder that we have to step in and do the job he's not doing. Okay? So I eventually charged all 200,000 members of the State Bar of California for not having valid licenses, and I had to do something because they were all involved in a felony racket. And I had to report it properly. It wasn't just mail fraud. I mean, it's false imprisonment, it's extortion, witness retaliation, obstruction of justice. Pardon me. There's a long rap sheet in Section 1961. So I encourage you to look at that statute because there are an awful lot of crimes that Congress has identified as RICO predicate acts. And as I said, it only takes 2 of those in any given 10-year period to constitute a pattern of racketeering activities. So I'm glad you followed through because a lot of people react the same way. They go, oh, you're making this up. You're full of BS. And then when they look further into it the way you did, they realize, no, wait a minute, the Congress wants private citizens to do this, and the Supreme Court has approved it, without qualification. So I think that's probably why the marshals never really caused any serious problems for me. Once they figured out that I knew what I was doing, they just leave me alone.
Do you find that the U.S. Marshals tend to be allies? It seems to me like maybe them, and up until recently, the Secret Service seemed above the fray in terms of the intrigues that seem to plague quasi-government activities.
Well, frankly, I reached the limit of these 2 marshals' knowledge pretty quickly because they don't spend their day reading law. They spend their day maintaining security in the courthouse and, shuttling criminals to and from detention to courtrooms and this kind of thing, you know what I mean? And then they do arrest people and they do that kind of investigative work, but they don't spend hours and hours out of every week reading federal law, and they don't bother getting involved in litigation. I mean, the job that they have to do may, focus for many hours any given week on, making sure that some witness is being protected, or making sure that some person who's been arrested is, not going to be shot because he's turned state's evidence. And then there's the whole, enforcement side of the U.S. Marshals, where they really are police, and they really are going out, investigating crimes and arresting people and confiscating contraband.
Thank you for that. That was my follow-up question. Are they enforcement officers? Yes.
Oh, yeah.
Okay.
If you need to report a felony, you can go to the Marshals, and that will satisfy your legal obligation, provided that it's, a federal offense. They may refer you to a sheriff. But it's good to make friends with the Marshals, because they can be your worst enemy, or they can be your best friend. So it's good to show respect for the office, if nothing else, because they do have a lot of authority.
In terming them as law enforcement, I was kind of going in maybe a tangent. We have a problem in this country with what I will simply call brainwashing of public servants. Police officers clearly don't know the law. They can't differentiate between a statute and an actual law. And it's an important distinction. I know you've made this distinction before, that statutes apply within the municipality, which takes us back to the federal zone again. Am I correct in stating that? In other words, what are statutes? Because even the tax code itself is predicated on statutes.
Okay, the word statute has come to mean lots of different things, and when you're talking to me, I restrict the meaning of that to the statutes at large. The statutes at large are the very first place where acts of Congress are published, and they are published in chronological order. Then, if they fit somewhere into the U.S. Code, let's say it was a modification or an amendment to the copyright law, that amendment will get codified into Title 17, which is a matrix, as you know. It's just 50 columns, and the rows are sections. But the U.S. Code is not the original acts of Congress. If there's some difference, for example, you may have noticed that I said the liberal construction rule was never codified.
Right.
In the RICO laws that showed up in the statutes at large, you will find that liberal construction rule, because that is the law back there. It just doesn't show up in the U.S. Code because it was never codified. Now, some people have come to redefine the word statute to mean something I don't entirely agree with. They're trying to say, well, statute law is not real law, it's not constitutional law, it's not organic law. I don't exactly know what point they're trying to make here, but I get the feeling that people who have come to adopt this other weird definition have been misled, and the purpose of that misleading is to steer people away from the statutes at large. You see my point?
Yeah, I do. And actually, this is where I wanted to get you in the conversation on this. I want you to make that distinction.
Yeah, well, statutes at large are where Congress publishes the official version of all their acts and resolutions and private acts. Everything goes in there. Treaties. If it's not in there, it doesn't exist. That's how important the statutes at large are. Okay? If it doesn't show up in there, it isn't a law. You can ignore it. Now, that's not to say anything about regulations, because that's executive side, that's executive branch. But when it comes to the Congress of the United States, the federal legislature, that's the official publication of all acts of Congress. Okay, so I'm not really sure what some of these other activists are talking about when they criticize statute law, because I don't think they've ever read the statutes at large. If they had, they would know that they're making a very serious error in their various teachings. I got into this one time with a guy who was trying to tell me that statutes aren't law, and it only took me 5 minutes to show him that his whole argument was worthless, and it wasn't going to get him very far in any kind of federal litigation. And he finally realized, the error of his ways, and he stopped talking like that. But he had habituated himself to, make this argument to everyone who was willing to listen. I said to him, you've got to be careful, because the Bible has a very, very serious punishment for false teachers. Mm-hmm. And that, he was really shocked by that. And I said, you're not teaching the truth. You're teaching a falsehood when you make this silly argument. The distinction that needs to be made is that Congress wears two different hats. Sometimes a statute will apply to people inside the states of the Union, and at other times a statute will apply only to federal citizens and resident aliens. Let me give you two really simple examples that are commonplace. The Freedom of Information Act was enacted and provided a remedy to people throughout the states of the Union and all federal territories and possessions to, obtain copies of federal documents. There's no restriction. If the document exists, the requester has a right to it. The requester doesn't have to say, I'm a resident alien, or I'm a federal citizen, or I'm not. If the document exists, the requester has a right to it. You see how clear that intent is? Mm-hmm. Now, contrast that with the Privacy Act. In the Privacy Act, the Federal Privacy Act, it says individual means citizen of the United States and resident of the United States, just like Subtitle A of the Internal Revenue Code. So if you're going to invoke the Federal Privacy Act in federal court, you better be an individual as defined in the law, because that law is federal municipal law. Do you see the difference?
Yes. In fact, you hear the key term there with individual. Isn't that even in itself kind of a tag put onto this?
Sure. Well, it's the same individual as the word individual on Form 1040.
Right.
It's the U.S. individual, right. And that's also a statute, but it's federal municipal law, okay? So if you're going to be invoking the Federal Privacy Act in federal court, you're basically telling the federal court that you're one of those individuals. They may not bother inquiring, if you know what you're doing. They'll just assume that you know what you're doing and that you're an individual as defined in the law. But that law is federal municipal law. Now, another similar pair is Title 42, United States Code, Sections 1983 and 1985. 1983 is a remedy for civil conspiracies, okay? Mm-hmm. But the courts have ruled that that's federal municipal law because it's a codification of the 1866 Civil Rights Act. There you go. We've just gone full circle.
Yeah.
Now, 1985 is not federal municipal law, and here's why. The Ninth Circuit has said 1985 in Title 42 is a law that implements the 13th Amendment banning slavery and involuntary servitude. Well, that's federal national law, as we now know. And the Ninth Circuit in Gillespie versus Civiletti ruled that this section of Title 42 implements the 13th Amendment. Well, that tells us that it's national law, because 13th Amendment is nationwide law, not municipal law. Do you see that distinction? Mm-hmm. Mm-hmm. I have to explain this a lot because when people get exposed to the difference between national law and municipal law, it's kind of weird. It's uncomfortable at first. They don't quite get it. But Congress can make laws.
Yeah, exactly. I mean, I was there. I still feel, we have a Congress that wears two different roles, basically legislates for two distinct bodies, but the distinctions are never really articulated in plain view. We have to rely on people like you or our own woeful inability to fumble through all the verbiage.
Oh, yeah. Well, let me put it this way. One of my favorite quotes is Mark Twain. And in half-joking sense, one day he said or wrote, "The only time the children are safe is when Congress is not in session." I mean, you got to realize these people are attorneys for the most part, and they have their own selfish agenda all the time. And I don't think they have a vested interest in making these things clear and keeping them simple. Let's just go full circle. If they had used the naturalization law right after the 13th Amendment, we wouldn't have had this invasion of the South and all of that subterfuge and all those machinations and all that ill will. And I think the issue would have been settled clearly. And I'm going to go even further. If Lincoln had done his job prior to the Civil War, maybe the Civil War could have been averted. Because the writing was on the wall. I mean, slavery was on the way out. But it took a horrible Civil War and over 600,000 casualties to settle that question. I think if he had proposed the correct constitutional amendment, history might have been different. I know that's speculation, but I generally don't trust lawyers because they just seem to be motivated to prolong litigation and make the law more complicated than it needs to be and embed all kinds of deceptions into these laws. And I'm kind of tired of it, particularly when these rogues tell me I can do this, I can't do that, and they don't even have credentials. Who are they to tell me what I can do and can't do? If they're impersonating a federal officer, that's a felony. I'm not the one committing a felony. You see my point?
Yeah.
So anyway, I'm very, very critical of the Congress now because of all these laws they've been passing ever since the Civil War. And they've made it extremely difficult for people to decide what does United States mean here. If it's got three meanings, maybe the motivation on the part of the Congress is to keep the confusion going as long as possible because it, raises more money for attorneys.
Here's, and one of the reasons why, and I know some of my listeners were a little stumbled by me covering this subject matter, I stayed away from it because I was involved with the Patriot movement back in the 90s and even up until about 2000, and I watched the contortions that they went through with verbiage, with the use of different devices. The UCC was a big one. There was legitimate facts and all of that, but there was so much distortion, it became almost impossible to filter it, and we watched a whole bunch of people go to prison. We had the Montana freedmen that wound up using different UCC devices to do all kinds of things that were just patently illegal. Yeah. We saw some of the great pioneers in the tax movement go to prison as a result of what I consider to be some very honest effort, but perhaps not executed well. So we really are kind of at this place where everybody's a little tenuous about how do I go forward, what do we do, or do we just go back to sleep and stay in confusion because we can't possibly understand any of this?
Well, I tried to utilize the courts as much as possible, and there are an awful lot of court cases reported in the Supreme Law Library where I was directly involved as counsel. And the frustration built to the point where I decided to shift into this full-on and non-stop investigation of missing credentials because I have the court cases to back me up. If these people don't have credentials, they're not judges. And these courts are vacant. And I mean the Supreme Court, too. I'm not stopping at the lower courts. I went all the way to the Supreme Court with my copyright case, and the Department of Justice told me 3 of those didn't have credentials. I have that, on Department of Justice letterhead. How's that for material evidence? That wasn't my conclusion. That was their conclusion, and I've had to point out to them, you, Department of Justice, are the designated legal custodian of this credential. You're supposed to have it. When they saw the law, they said, hey, Paul, you're right. We're supposed to have it. We have it for these, we don't have it for those. There you go. So at that point I realized, why petition, a court if the court is legally vacant and all these people are racketeering, they don't have credentials, they're committing mail fraud. So I shifted, a lot of my emphasis shifted out of litigation into a protracted, still ongoing investigation of all these missing credentials, and of course, I publish all the results on the Internet because I want America to hear this. I want America to know our courts are infiltrated. We don't have remedies there. So maybe in dealing with the IRS, the proper way to handle it is to solve these issues administratively and get them to back off. And I'm happy to say we've been very, very successful in that area because, among other things, we've proven that the IRS doesn't have any authority to display Department of the Treasury on any of their pre-printed forms or any of their correspondence. So what's the first question we need to ask them? Somebody comes to me and they hire me, I have this IRS problem, what should I do? And I said, show me their correspondence. Does it say Department of the Treasury? 99.999% of the time
I can tell you right up until the last 60 days it does, because I just got another letter from them. It's just, it never ends. But yeah, they still put in Department of Treasury on their letterhead.
So you know who they are? We found out who they are. They are what was left over of the untouchables after alcohol prohibition was repealed. Because alcohol prohibition was secretly financed by the petroleum cartel, they wanted a monopoly in automotive fuel. So they secretly financed the women's Christian temperance movement to make it a big moral issue. And then when that petroleum cartel was perfected, when that monopoly for automotive fuels was in place,
right,
and alcohol was no longer being used as a fuel, now it's not a big moral issue after all, we're going to repeal prohibition. That was where I stepped in. I said, what happened then? A Supreme Court case came down that said this federal alcohol administration is no longer legal inside the states of the Union, but a compromise was reached allowing them to retreat to San Juan, Puerto Rico. And that's where they are. They are doing business as DBA Trust Number 62, domiciled in San Juan, Puerto Rico. And I can show you a court case that says, yeah, they have a Secretary of the Treasury out there too. And I can show you the regulations for Title 27.
I've read this. This is beautiful stuff. Yeah.
Yeah. Well, if you go to Title 27, look up the definitions of revenue agent, secretary, and secretary or his delegate. Right in there, it mentions Puerto Rico. Those are offices in San Juan, Puerto Rico. So there you are. It's in the Code of Federal Regulations. They're not Department of the Treasury, the one in Washington, D.C. They are a second Department of the Treasury impersonating the de jure one. And I just put the question to them. We've done this for my clients now over 24 times. The clients just, their eyes just bug out. Wow, is it that easy? I go, well, that's the first question to ask because 99% of their pre-printed forms display Department of the Treasury, and they're putting them through U.S. mail, so that's a felony. That's a mail fraud.
Has anyone successfully yet prosecuted them by going to the postal inspectors, lodging the complaints? And you've already outlined this. Once you know the commission of a felony, you're responsible for reporting it, or you, I guess, by contrast, are also guilty of a felony. Is that correct?
If you don't report it, yeah. That's Title 18, United States Code, Section 4.
Okay, so what does a federal postal inspector do when you show him? I mean, I got a box full of these things here. I keep looking at them going, if that's true, that's cash in the box. Is anybody prosecuting the IRS for mail fraud?
Not presently.
Wow.
I think the people at the Postal Inspection Service just want to keep their jobs, and if they rock that boat, they'll probably get fired. That's my take, because I've never seen them go after an IRS agent. But let me tell you this. We were talking about the difference between statutes at large and the U.S. Code. There's an act of Congress that was signed by President Clinton called the IRS Restructuring and Reform Act of 1998. Okay. It was not codified in the U.S. Code. So you need to know about it, number one. And it did another thing that people don't generally know because they don't know about this law. It elevated the Internal Revenue Manual to the legal force and effect of law. Prior to that, it had no legal force or effect. But it now reads, if an IRS officer or employee violates any provision in the Internal Revenue Manual, they can be terminated for that. That's very, very important. So we just hold their feet to the Internal Revenue Manual because they don't know how to do assessments. They never follow the Internal Revenue Manual. And they have to answer correspondence within 30 days. That's one of the provisions in the Internal Revenue Manual. So we go to them and we say, look, you have 30 days to produce an authority to display Department of the Treasury on this correspondence you've sent to me via U.S. mail. And if you don't do that within 30 days, you're in default and you can be terminated. Because the IRS Restructuring and Reform Act authorizes termination of people like you for violating this provision in the Internal Revenue Manual. They freak out. These IRS people don't want to lose their jobs either. When they realize that they're looking at termination and maybe a felony charge, they usually retarget. That's what we found, that they're scared because no one has showed them this law up until now. and they thought they were U.S. Department of the Treasury, right? That's what everyone in their office says, right? Well, wouldn't they all know? That's how bad this deception is. Okay, but anyway, back to the distinction between the U.S. Code and the statutes at large. You see, the RRA 98 is a statute. It's an act of Congress, but it was never codified in Title 26. So the fact that it's not in Title 26 is highly significant. You can read all of Title 26 and you won't find this law.
I see some questions kind of percolating through the chats. There's 2 chat rooms. Let me open it up. If it's okay with you, Paul, to stay on, we'll go to the bottom of the hour.
Okay.
And that'll give some people time if they want to call in. For those of you on the chat on offplanetradio.net, the number is listed there. I'll give it out for anybody else. 717-910-0544 is the call-in number direct to speak with my guest, Paul Mitchell. I didn't think it was possible to get my head blown off in this interview, but you did a pretty amazing job, just some of the things that you said, and it's like the gravity of this is immense in trying to understand the average person out there at this point, and I don't like talking down. Most people not only don't know about this, they really don't care. And that disturbs me more than anything, the mindset that complies with all of the garbage that's come out of this federal zone. The taxes are one aspect of it. The other side of it is clearly what they've been doing since 9/11. Last January with the enactment of the NDAA, and I watched all kinds of people freak out about that. My take on the NDAA was largely that it applied to a specific type of citizen. Was I true in my assumption about that?
I have to beg off there because I have not looked into that law in any detail.
Okay.
And I do know that this concept, just the raw concept of detaining people without a court remedy, without habeas corpus, it's totally unconstitutional. But I haven't read the details. I don't know if it applies only to federal citizens or whatever. So I'm sorry, but I haven't been retained to provide a professional opinion, and I don't want to just come off the wall.
No, I actually appreciate you saying that as well. Okay. That's fine. One of the questions that I saw in the chat room had to do with signatures, and I don't know if you want to touch on this at all. They wanted to know how they were supposed to sign their name, I guess, on documents. Do you deal with that at all?
Yeah, sure. A lot of the research we did on signatures came out of and resulted as a consequence of what we learned about 1040 forms. And it came out recently in the context of laws that define when an assessment is valid. Because I get asked that question all the time, is this assessment valid? Is that assessment valid? Is this notice of federal tax lien valid? Blah, blah, blah. And there's a law in the Internal Revenue Code that says all of these documents have to be certified under penalty of perjury. You need to know that. And, of course, the courts have ruled that you cannot alter that perjury declaration on Form 1040, and if you do that, it renders it invalid. It's no longer a valid tax return. Mm-hmm. So my point has always been, well, if it's true that you can't alter that perjury jurat on Form 1040, what about assessments? Don't they also have to be verified under penalty of perjury? Well, that's true. They do have to be verified under penalty of perjury. But when I looked into this is part of the deception that you and I are hitting on. I didn't find, any court cases that said that in the list of court cases under that particular statute. That's Section 6065. I just happened to stumble on it one day, and you know where I found it? This was in a court case that was listed under Title 28, that's judiciary, Section 1746. And that's a real sleeper, because if you read that statute and you don't know what you know now, you might miss what's going on there. But that particular statute authorizes certifications to be made under penalty of perjury in 2 different modes. One is within the United States, and the other is without the United States. Does that sound familiar now?
Yes. Yes.
Within the United States means within the federal zone, and when you're declaring something under penalty of perjury and you're without the United States, all you need to do is add the clarifying phrase, under the laws of the United States of America. And it's very, very clear when you understand the distinction between the United States as used in that statute and the United States of America, and how the one is juxtaposed against the other. You always want to invoke that statute if you're required to verify something under penalty of perjury, for example. You want to know about that statute, and you want to know which subsection to invoke, because if you invoke the wrong one, you're telling the federal government you're one of their subjects, you see? So
Yes.
you want, if you're outside the United States, you are then probably inside the 50 states of the Union, and the 50 states are synonymous with the United States of America. So you just add parenthesis 1, close parenthesis, to the section number, and that points the reader to the proper mode of that invocation. I go into this a little bit in my book, and we elaborate on it in a whole lot more detail in a document that I filed in a lot of state and federal courts called 31 Questions and Answers about the Internal Revenue Service.
I've actually used this. Yes, this is a great document.
Yeah, that's a wonderful question to put to people. You see, there's no requirement that you notarize a tax return. And the way Congress made that possible was to enact this statute. And all you have to do is know that there's a distinction between within the United States and without the United States. And when people understand that distinction, then they become sensitive to the fact that, well, sometimes the United States is not, when the word or the phrase United States shows up in a law, it may not be what, everyone thinks it is. That brings us back to that triangle when we started out this interview. It's basically the same problem, and they're not being crystal clear when they should be. And in fact, they should be clear all the time, because void for vagueness is a well-established doctrine in federal jurisprudence, and it basically renders any law void from day one, not from the day a court might decide that it's vague. Void for vagueness says that a law is, if it's unconstitutional due to vagueness, it was never a law. Yeah, its unconstitutionality dates from the moment of enactment, not from any decision so branding the act in question. So all this vagueness, it really ends up nullifying a lot of these laws if they can't be understood by the guy on the street. That's the rule, by the way, the Supreme Court has given us. If the men and women of common intelligence cannot understand a statute, that's the test. It's not what a judge thinks. It's what, a jury thinks. It's what you and I think. If we can't understand a law, and it's written in plain English, if it's not understandable, or if the term United States has some, special definition or limited definition or an unconstitutional definition, that type of vagueness should nullify all of these laws, because Congress is guilty of, committing fraud.
But we have, 2 million lines of tax code that today is the means by which the average American is forced into compliance. Businesses rely on basically, most businesses that I've encountered rely on legal advice coming from CPAs.
Yeah.
And this was actually an encounter, I'll be a little transparent here, this was actually the encounter that I had with an employer 6 years ago, who told me in no uncertain terms that he was going to enforce the levy that was placed on my salary on the advice of his accountant. And I said, well, you might want to have an attorney examine it, because I handed them an affidavit of 30 pages that detailed why the notice of levy, notice it wasn't the levy, it was the notice of levy, was not enforceable, and it turned into a huge battle. And he told me that he relied on the advice of his accountant, and I advised him that he might want to seek, counsel from somebody, because the CPA was simply acting out of his programming.
Yeah. Oh, that's been going on for a long time, and it's very widespread, and it's totally illegal, primarily because the Internal Revenue Manual says you can't do any collections before you've done a procedurally proper assessment. That's right in the Internal Revenue Manual in several places. The prerequisite for a lien or a levy, they both say you have to have an assessment done properly before you can even commence any kind of collections at all. And that's where we're jamming them up, because we proved to the IRS that they didn't do a procedurally proper assessment. They can't produce proof of a procedurally proper assessment because, you know, the bottom line, literally the bottom line where the assessment officer tries to sign it, it's not signed under penalty of perjury, so they're violating 6065.
My experience, they're not signed at all. These are computer-generated forms that come through. There's no human being behind them. That was one of my initial complaints about this.
And
who the hell do I talk to about this?
Right, and they haven't done an assessment, so they can't do any collections at all. They can't mail a levy or serve it or, you know, even start a levy. They can't commence any kind of collection at all unless they've done a procedurally proper assessment first. And that's crystal clear in the Internal Revenue Manual. They don't even know their own rules.
Is a levy or a lien not supposed to be enacted under signature of a judge? Is there not a judgment process behind the ultimate collection on these?
No, they can collect under authority of the Internal Revenue Code if they follow the code. And for an assessment to be procedurally proper, it must be dated and signed under penalty of perjury by an assessment officer.
I see what you just did there. That's beautiful. They never get that far.
No, they don't. Well, they can't, furthermore, because there's no liability statute for Subtitle A. So if they even go that far, which is 1 in 1,000 of the ones I've seen, then you charge them with perjury because there's no liability statute. You know, another question we ask them all the time is, why don't you list Commissioner versus Acker on your website, you know, irs.gov? Do you know what Commissioner versus Acker said? You can't create a tax liability with a regulation. That's a U.S. Supreme Court holding, and it's a standing case law. They don't list that authority on the IRS website, except in a completely different context. They don't cite that particular aspect of the decision, but it's crystal clear in there. The law does not permit a tax liability to be created solely by means of a regulation, absent the requisite act of Congress. I don't know if you know the history of me, but, you know, we've served a subpoena on the Secretary of the Treasury to produce the act of Congress. And not only did he fall silent in the face of that subpoena, but George Bush terminated him about 60 days after that subpoena was served. That was Paul O'Neill. I don't think the reason for his termination was that subpoena. It was just sort of a coincidence that we served him, and then soon after that he got fired. I think he got fired because he was a witness to all these cabinet meetings where they were planning to hit Iraq before 9/11.
Yeah.
And he was a witness to all these discussions, and, you know, he raised objections. He goes, why are we going to war with Iraq? He didn't believe there was any justification for that, so George W. Bush terminated him. But one of the consequences of that termination was that he never answered the subpoena, so he went into default. So the Department of the Treasury in Washington, D.C., the real one, they failed to answer a subpoena for the act of Congress that creates a specific liability for Subtitle A. So they're in default. The whole department's in default. So there is no such statute at large. There is no liability statute. They did it in a regulation, but we show them the Supreme Court has said you can't do that. The law does not permit. That's what the Supreme Court said. The law does not permit this. The administrative agency just can't, do it off the wall. Because why? Because only Congress can make law, and the tax liability must be imposed solely by act of Congress when it comes to federal law. And when we go to the IRS and we say, look, are you aware that there's a Supreme Court case? And they look at us and their eyes just glaze over. Well, we didn't know that case existed. And I go, well, why don't you cite it on your website? Well, we do, but it's in a different context, and it's only, it's only the volume and page number. It's not the parties. So they just start, waffling. And we go to them, there is no liability. Furthermore, that regulation imposes liability on federal citizens and resident aliens. So why are you asking my client to commit perjury over here? You're telling him he has to complete Form 1040. He's not a federal citizen and he's not a resident alien. What are you doing? That's subordination of perjury. That's a separate federal felony. So they usually back off pretty fast. When we get down to talking felonies, they usually just retarget. You need to know this stuff because you can pass this on. This is not unique to me. This is all right in the law, okay? If they're trying to solicit a 1040 from somebody who's not a U.S. individual as defined, they need to be told, to stop. You gently do it. You say, look, you're practicing law without a license, so you better stop. If they continue, then you just escalate. You say, look, you're pressuring me to fill out Form 1040, and that's subordination of perjury because this form is not valid unless I execute it under penalty of perjury. I can't do that because I'm not a U.S. individual. Bingo. This brings us full circle. We're back to this question of municipal law again, and the meaning of United States in the Internal Revenue Code.
Yeah.
State is limited to District of Columbia. It's right in 7701. It's definition of state and then definition of United States. That all came out of the book, The Federal Zone. So we've come full circle now because it all comes back to the meaning of United States in that context. And what is the meaning of U.S. individual in that context? It's not hard to do if you know where to look. You take the meaning of individual, then you go down to subsection A30, and there it says, U.S. person means the following things. Citizens and residents of the United States, and then there's a long laundry list of juristic entities, artificial juristic entities like associations, corporations, partnerships. Okay? So the only living human variant of a United States person as defined are federal citizens and resident aliens. That's what a U.S. individual is defined to be in the law. It's just a variant of United States person, which is the catch-all phrase, but the components of United States person are federal citizens and resident aliens. Those are the living, breathing human variants, and then all the others are artificial juristic entities. So this is another way we broke the code. The conspicuous heading on Form 1040 says U.S. individual income tax return. There you are.
Yeah.
It's in your face.
See but that language right there. And you could ask what you would call a reputable professional like an accountant or even the average attorney. They're going to tell you it's an individual tax form. They don't tell you it's a tax form for an individual which is defined in a very specific way.
Oh, yeah. This is backed up with the regulation at 26 CFR 1.1-1 where it says the liability falls on citizens of the United States and residents of the United States. There it is. It's just black and white. So you just need to know what small c citizen of the United States means right there in the implementing regulation. And the courts have ruled when it comes to taxes, the regulations are, the last word. So you go to that regulation and you say, well, these are the people that are supposed to, evidently, in theory, are supposed to fill out Form 1040. They are U.S. individuals, right? Federal citizens and resident aliens. I really wish Congress had used the word federal citizen way back, beginning in 1866. It sure would have clarified an awful lot of code covering many, many generations. I have to fault them for allowing all this deliberate confusion and obfuscation to work its way into laws that we're supposed to obey. They're just being, selfish and megalomaniacs back there.
Well,
and
it feels even darker than that to me, and I don't need to go there, but I have the sense that the confusion has served their system well because they've got near universal compliance with an IRS code that probably doesn't apply to, I don't know, pick a number, 80% of the people that file them every year?
Oh, more than that. if there's no liability statute, then that's true of federal citizens as well. You see, they can't create that liability with a regulation.
Got it. Yeah, I see what you're saying there. They haven't even created anything that requires anybody to do this.
Yeah. And of course, right after JFK was assassinated, what happened? Johnson signs the UCC into law, right?
Yep.
And basically, the way the UCC is allowed to operate is that they make this presentment to you, and if you don't rebut it, then it becomes fact. In other words, they use your silence against you.
Yes.
And that's a violation of the Fifth Amendment. That's one of the ways that Leroy Schweitzer, got in trouble, quite frankly. He wasn't totally correct. As far as I'm concerned, he wasn't totally correct about some of the things he was saying. He was trying to sign confessions for other people, in effect, and you can't do that. But he was trying to say, well, their silence means they're consenting to or admitting a felony. I said, no, Leroy, they have a Fifth Amendment right to remain silent as well. You can't use their silence against them in the way you're doing it. But he was so sure of himself because he had these statements from credit card companies and so on. They were setting him up, they were honoring some of his documentary drafts and just setting up all his people. And then they lowered the boom on him. But the basis for, his documentary drafts was that some government officer or employee had fallen silent in the face of one of his accusations, and he took that to mean that they were confessing. And I found that flaw in his work, and he hated me for it. He said, well, his people put me on a plane, and they said, you're going back to Arizona, and you're never coming back here. I went, well, I'm just telling you what I know. You can't use someone's silence against them in that manner. Okay? It's just good to know that, because when it comes to the UCC, it has some basic fundamental flaws. We started to go down that road in a San Jose case. This dentist hired me, and he was using Leroy Schweitzer's documentary drafts. And I thought it was in good faith, because Leroy was showing people these credit card statements that reflected, a deduction in the debt after tendering one of these documentary drafts.
Yes, I remember this.
So a lot of the students were, taking that in good faith and going, well, it's working, his process is working. But in the San Jose case, I wanted to go in on behalf of the United States and attack the UCC, because this signature by accommodation, or this conclusion that the IRS draws from your silence, is not correct. It violates the Fifth Amendment. They cannot use our silence against us the way they do. They send out bills, and then if you don't rebut it, then they just move to a lien, or even worse, they'll foreclose on people's homes. Yeah, it's pretty ugly out there. I've been in the front lines for a long time, and I really have to fault the courts for not upholding the law as written.
Closing minutes here. I want you to give out information about your website, what people need to know about your Supreme Law Firm, the availability of the Federal Zone, and anything else you want to leave us with tonight, Paul.
Oh, okay. Well, after the book got to know that you don't have access to that message archive unless you pay the subscription. So the Supreme Law Library, what you see when you peruse the tables of contents is only like the top 10 or 15% of the whole library. There's a lower floor, if you will.
I got a caller here. Let me bring this caller in. Hello,
There's
caller.
There's a lot more to it that you will see if you subscribe to our discussion list, because I can show you, how to get access to the things that don't show up to people that are just, browsing it for free. Hello?
Yeah, we're still here.
Okay.
Sorry. I had a caller trying to get in, but I don't know if the call dropped or what. Yeah. Are you there? Hi, caller.
I noticed that Paul put L. Barcroft's book in the Supreme Law Library not long ago. And I was wondering if Paul had a comment on the FSIA, the Foreign Sovereign Immunities Act.
Did you hear that, Paul?
Yeah, I haven't read the act, and you need to be careful, because there are acts of Congress that use the word foreign in a municipal context. And in a municipal context, the states of the Union are foreign with respect to the District of Columbia. So a sovereign who may be a state citizen, say, out in one of the states of the Union, may be considered a sovereign in the sense of that word as defined for purposes of that statute. But I just haven't read it, okay? And you've got to be really careful, because sometimes Congress is wearing this other hat, and it's enacting municipal law, and in the context of laws like that, state citizens that inhabit the states of the Union are foreign. They are outside that jurisdiction. Okay? So, Foreign Sovereign Immunities Act, it might be, and I'm saying this because I haven't read it, and I haven't, been asked to evaluate it and review it and look at the court cases that have been decided under it, but it may actually apply to state citizens who are outside federal municipal jurisdiction. I'll give you a really classic example that's in the context of this post-Civil War era. Just before the Secretary of State declared the 14th Amendment ratified, the Congress enacted a real sleeper law called the expatriation law. Have you heard about this?
I have not.
Okay. The whole story is written up by a woman who has passed away. Her name is Linda Lyon, and she's in the authors subsection. So at supremelaw.org /go to authors, go to /LYON. That's the last name of this author, and she's written an incredible piece. I think it's entitled "The Day Our Country Was Lost Without Firing a Shot," something like that. And she goes through this whole era right after the Civil War ended, leading up to the Reconstruction Acts and going through Johnson's veto and all that stuff. And she found this little gem that's called the Expatriation Act, and Congress has recognized the authority and the right of citizens to basically expatriate. Now, some people read that and they think it means to, move to another country and expatriate from, any association with America. But after I read Linda Lyon's analysis of this act, I realized, she makes a very persuasive case that was the back door for anybody that did not want to get sucked into this 14th Amendment status. And, of course, Congress wrote it in such a way that people could be easily misled about to whom it applied. But she convinced me that it was a back door for anybody that didn't want to get sucked into this new legislative democracy that was the real intent of this 14th Amendment brouhaha. So look that up. I think I have links to the actual statutes at large, and if not, you can find it in any law library. I can't remember if I actually scanned that law. It's not very long. I think it spans like maybe 2 pages at most. But it's in this same context that the states are foreign with respect to the municipal jurisdiction of the federal government. So state citizens are legally foreign with respect to D.C., just like a corporation chartered by Congress is likewise foreign with respect to any of the states. It's a hard transition for a lot of people to make, but the Expatriation Act can be applied to people that just don't want to be part of this 14th Amendment crowd. It's right in there in the law, and the fact that it was enacted like just days before the 14th Amendment was declared ratified, I mean, that has to be more than coincidence. So I hope that helps you, but as far as the law in question, I haven't really done any serious work on it, so I'm going to have to beg off.
Okay, so it sounds like that Al's analysis is similar to Ms. Lyon's in that the foreign aspect is outside of the federal zone.
Correct.
So it sounds like it lines up with what everything you've been saying.
If foreign means, outside the municipal jurisdiction of the federal government. And we know what that is now. Geographically speaking, it's the District of Columbia, Guam, Virgin Islands, American Samoa, Puerto Rico, and all of these federal enclaves that have been ceded to the Congress by a state legislature, like military bases. Okay, these are all scattered little islands of, geography, but when you combine them together, they are the area where Congress is City Hall. They are the area that enjoys exclusive federal jurisdiction, and the authority comes out of the U.S. Constitution in two places. Article 1, Section 8, Clause 17, that's the, enclave clause, if you will, and then there's the territory clause at Article 4, Section 3, Clause 2. And when you take those two authorities and you combine them, the areas that fall into one or the other, taken together, are the area where Congress is the municipal jurisdiction, where Congress has exclusive legislative authority. There's no state governor, there's no state legislatures, okay, and there's no state courts. Congress does all the lawmaking for that area. Now you contrast that with the states, where, they are stars on the flag, they have their own governors, they have their own state legislatures, they have their own state courts. All of those laws are foreign with respect to D.C., just as D.C.'s laws are all foreign with respect to us. So, in that sense, D.C. is foreign with respect to California, and California is foreign with respect to D.C. It's mutual in that respect. So the concept of foreign and domestic is kind of a floating relative concept, just like I stress that distinction between foreign and domestic corporation.
So essentially the definition is contextual. You have to be able to read exactly to whom it applies.
Right. And a place to look to determine whether it is national or municipal is to see if Congress has played games with the definition of state.
Exactly.
Now, for example, if you want to see a real classic instance of a federal municipal definition of state, even though Congress is not supposed to do this, they've been doing it a lot for a long time. Look at Internal Revenue Code, Title 26, Section 3121E. You should write that down, because this is a classic one, and we have confirmation from experts inside the federal government. It defines state to include only D.C., Guam, Virgin Islands, American Samoa, and Puerto Rico. You see, there's a rule of statutory construction here. Let me give you an example. If Congress defines the word car to include Pontiacs, Chevrolets, and Oldsmobiles, well, then a Cadillac's not a car for purposes of that law. And the rule is a Latin rule, inclusio unius est exclusio ulterius. Any term that's omitted must be inferred as an intentional act of Congress. So if Congress doesn't mention the 50 states, or if Congress doesn't mention California or Alabama or Florida, the omission of those places must be inferred as an intentional act of Congress. This is a rule of statutory construction. And that's why the definition of state at 3121E in the Internal Revenue Code is so pregnant with meaning, because it doesn't mention the 50 states. It doesn't mention the several states. It's restricted to those limited areas that are not states. And you got to know that. You got to know that this is not an all-inclusive sort of meaning of state. It's a very restrictive meaning of state. So they're talking about a different kind of state. Another thing that Congress did, and I'm really pissed off about this, they hijacked capital S state. That's their municipal, subdivision now. And when they want to refer to a State of the Union, they change the S to small s. Well, that violates the Eisner Prohibition. The Supreme Court has said you can't modify the Constitution by an act of Congress. Congress is constantly redefining state and United States, so they hijacked the term that's in the Constitution. The term that's in the Constitution is capital S state. That's a State of the Union, a star in the flag. But in federal law, it means something else. And when Congress wants to refer to a State of the Union, a star in the flag, they use a small s in state. I mean, it's really subversive, I have to agree with Randy. I think it's dark and malevolent. But, I have to stay close to the facts and the law.
Right, yeah. And that's your role in that. Did we answer your questions, caller? Did you have anything else you wanted to follow up?
No, it's beautiful, beautiful. And one other addition is this Buck Act. Don't the territories and the enclaves, isn't there some overlay that also adds into that? Because in Title 4 or 5 of USC, don't they also redefine state there?
Oh, yeah. It gets worse because, these political subdivisions that have overlaid the de jure states of the Union, the guys that have underwritten the federal debt and so on, and they're collecting money ostensibly for that purpose. Okay, they're doing the same thing in their law. I had a client hire me to examine the tax law in California. Yeah, it does the same thing.
This is a franchise tax board, the franchise board?
Franchise tax board, yeah. That's in letters, let's see, supremelaw.org/letters/FTB. That stands for Franchise Tax Board.htm. Yeah, take a look at that document. Man, that'll blow you out because it proves that California isn't even mentioned in the definition of state. So they're not even talking about California in a California law. It's so amazing. Yeah. But yeah, the Buck Act was another one of these redefinitions. Richard McDonald did a pretty good analysis of that. Do you know how to limit your search in Google to a particular domain? If you want to look up...
I do.
Okay, great. So just limit the search to supremelaw.org and search for Buck Act. And I know there's stuff out there. We've been at this since 1990, so I don't have photographic memory of all the library's contents, but that's why we put it on the Internet so you can search it with Google and Bing. So I think Richard McDonald's article on the Buck Act is still out there.
Okay, Paul, thank you so much.
You're welcome.
Bye.
Bye-bye.
Thanks, caller. It was, wow. We could probably go 4 or 5 hours, but I know that, it's your evening. It's my coming up on early morning. And I really appreciate deeply you coming on the show, Paul, and being so generous with your expertise and all the information. There's a couple places on the file, the audio file, where I just bookmarked it because I want to go back. Anybody that's stuck with us through the show tonight, you'll be able to download the files from wolfspiritradio.com. If you go onto the website, I believe Dave will have that up in pretty timely order. It may take me a couple of days to post it to the website at offplanetradio.com, and we'll try and let everybody know the show's up. But you need to listen to this from beginning to end and grasp that we really did close a lot of loops on a very complex subject tonight. There's a ton of information in that can begin to launch you into understanding the things we talked about. Complex stuff made very simple by our guest, Paul Mitchell, tonight.